and the Indian Supreme Court came with a very, very short decision. It in essence said, we find that the High Court has not merely set aside the original show cause notice, but it has made certain observations on the merits of the case and has given directions to the TPO which virtually concludes the matter on that limited issue, which virtually concludes the matter. And then it went on to say, on that limited issue, we hereby direct the TPO to proceed with the matter uninfluenced by the observations and directions given by the court. In other words, put that aside. And the question in all the subsequent cases is, what exactly did the Supreme Court mean by the words on that limited issue? So clearly the Supreme Court wanted to throw out part of the decision, not the whole decision, right? Because otherwise it would not have used the words on that limited issue. But now the issue is, does it refer to the observations made by the High Court, or does it refer to the directions given to the TPO? Quite frankly, I think it's not strange for courts to make observations about a fact pattern. That is part of their job. However, if you think about the independence of powers of government, you know, the judiciary should not tell the executionary what to do, right? And I think personally that the Supreme Court said that the inspector should go and reassess the case, and he doesn't have to follow the instructions or the directions of the court, right? On that limited issue, the sentence has given directions to the TPO was out of place because the court is there to judge. The court is not there to tell the tax authorities what to do, right? That's my interpretation. But if you look at the LG Electronics decision, which I discuss on my channel in a different video, you can see LG Electronics looked at the case quite slightly differently, because they said the High Court has made certain observations. They quote the same decision from the Supreme Court, right? You can see that by the wording, but they just emphasize different texts. They say, we find that the High Court has made certain observations on the merits of the case. On that limited issue, we hereby direct the transfer pricing officer to proceed with the matter uninfluenced by the observations, directions given by the High Court. So for them, it seems like the observations about the merit of the case is what the tax inspector should ignore. And to me, that does not make much sense. But again, I mean, these are the judges; they are the ones who decide. And if we look what LG Electronics went on to say about this, we now got to the ITAT bench, right, in Delhi, about LG Electronics, and Maruti Suzuki came up as part of a bright line test, but that was not the whole issue of the case. Have a look at the video to see what it was. It was about a blue ocean strategy, and to what extent there was an agreement between LG in Korea and in India that LG India should follow the group marketing strategy in India, and whether it should be compensated for that. So in 29.7 in the LG Electronics case, the court says the judgment of the Honorable Jurisdictional High Court in Maruti Suzuki is a perfect depiction of the last situation as discussed above, and then it will say what it is. It says, from the relevant extracts of the judgment and the summary of its conclusions as produced above, it can be noticed that the decision can be conveniently divided into three parts. So the 10 or 11 points that we just looked at is broken into three parts. The first part upholds the character of brand promotion expenses for the foreign associated enterprise as an international transaction, and this is what this series of cases is about. The transfer pricing assessing officer in India can only make a transfer pricing adjustment if it is an international transaction. If it's not an international transaction, there can be no adjustment, the way I understand it. So you must start with whether there is an international transaction, and Maruti Suzuki has all along said there is no international transaction because this was an imputed transaction, right? Second part Compromising of 4 subpoints outlines the principle of law into 2 parts. The first part, incurring A&P expenses by an independent enterprise domestic entity, does not require compensation by the Indian enterprise. Well, we saw that in the Maruti Suzuki decision. Second, if the A&P expenses are incurred by a domestic entity, then there is a requirement on the part of the foreign entity to compensate the domestic entity in respect of the advantage obtained by it in the form of brand building, to the extent the expenses are more than what similarly placed comparable independent domestic entity would have incurred. So he's just summarizing the Maruti decision. And then he says the third part, comprising of 4 subpoints, deal with the merits of the case in pointing out that where the TPO went wrong and how he should go ahead in the fresh proceedings restored to him. And this was this issue of you've got to find the right comparables. You can't compare car sale companies to tractor sale companies. And the court then went on to say, because then it looks at the Supreme Court decision, right? And it says 2 things emerge, the ITAT, sorry, from the judgment of the Honorable Supreme Court. First, that the aforesaid discussed Part 1 and Part 2 of the judgment have neither been considered nor commented on by the Honorable Supreme Court. So in other words, the stuff that the Delhi court said about the bright line test, the ITAT Delhi here says basically is okay, right? Secondly, only the afore discussed Part 3, being on the merits of the case, has been summarily touched upon by laying down that the TPO should decide the quantum of the determination of the ALP, in other words the arm's length price, in respect of the AMP expenses, uninfluenced by the observations, directions given by the court. So what the ITAT says here, as tax inspector, the only thing that the Supreme Court said is that you can go and decide what the price should be all by yourself. You don't have to listen to the instructions of the Delhi court. But I'm not sure they say that you should ignore their observations, right? Because they go on to say in 2912, the decision of the Honorable Jurisdictional High Court on the merits of the case has not been overruled either impliedly or expressly. I think that's a wonderful bit of Indian English there. I think the English or the UK idiomatic expression would be implicitly or explicitly. Yeah, right. 2913. It is noticed that with the advent of the judgment of the Honorable Supreme Court, the directions given by the Honorable High Court to the TPO for determining the arm's length price has lost the tag of binding false. Now the TPO is free to determine the arm's length price in any ways open before him. So he can use the bright line test, but he can also use something else. And this is it's more in line, I think, with what I also initially said. What the Supreme Court, I think, meant was it's not for the judge to go sit on the chair of business, right? Or for the tax inspector for that matter, but it's also not for the judge to go sit on the chair of the inspector and tell him how to do his job. The court can only tell the inspector whether he was right or wrong, and then the inspector can do it over, but the court can't tell them how to do it over. And now we come to the Maruti Suzuki case from 2015. And the story will not end here because it has been appealed to the Supreme Court in India and with a number of other cases. I've not seen publications of the Indian Supreme Court on AMP expenses. I know there are a number of cases before them, but I don't think this one or any of the other significant ones have been decided yet. So let's just go through what the court in 2015 says. And it starts by referring to a fourth decision, and that was the Sony Ericsson mobile decisions, which came after the ITAT special bench. I will also just the ITAT special bench case that we talked about in the previous slide. It was a special bench decision in the sense that the ITAT decided that the question of how to deal with AMP expenses in India is so important, it covers so many different taxpayers, that they put together a special bench to decide the issue at large for the majority of the cases, right? And now the Indian Delhi High Court basically we'll see comes and say, well, if you look at Sony Ericsson, which came after the ITAD decision, Sony Ericsson just said that the special bench got it all wrong. So we start over again. And it says the decision of this court in Sony Ericsson Mobile Communications 29, the summary of the conclusions: 1, the bright line test was judicial legislation. In other words, it's legislation by the court, not by the lawmaker. By validating the bright line test, the special bench and LG Electronics went beyond Chapter 10, which is transfer pricing. Even international tax jurisprudence and commentaries do not recognize the bright line test for bifurcation of routine and non-routine expenses. Now there were other issues discussed here as well, right? As to whether when you apply TNMM, whether you can then take out, whether you apply to the whole company or just to one transaction, and when you can take one transaction or part of one transaction out. So that refers to that. And then point 12, after the order of the Supreme Court case in Maruti Suzuki, the judgment of the Delhi High Court does not continue to bind parties. So the 2010 decision doesn't work anymore. This position was misunderstood by the majority of the special bench in the LG case. And then because we're actually in the 2015 Maruti Suzuki case, which quotes the Sony Ericsson case, we get back to what the Delhi High Court in 2015 says about the bright line test. It says preliminary issues. One preliminary issue that requires to be addressed is whether, on account of the decision of Sony Ericsson, it would be open to Maruti Suzuki to question the existence of an international transaction involving it and its associate enterprise SMC as far as the A&P expenses are concerned. And the court says yes, you're allowed to ask that because the Supreme Court has basically thrown over the 2010 Delhi High Court decision, which said that there was an international transaction, right? So in 44 it says, in the present appeals, the very existence of an international transaction is an issue. The specific case of MSIL is that the revenue has failed to show the existence of any agreement regarding the A&P spend of MSIL. The bright line test has been applied to A&P spent by MSIL, A, to deduce the existence of an international transaction because they imputed the transaction, there was no written agreement, and B, to make a quantitative adjustment to the arm's length price to the extent that the expenditure exceeds the expenditure by comparable entities. It is admitted that with the decision in Sony Ericsson having disapproved the bright line test as a legitimate means of determining the arm's length price of an international transaction involving A&P expenses, the very basis of the revenues case is negated. In other words, after Sony Ericsson, you can't use the bright line test to impute a transaction which never happened. And the court then goes on to say, as regard the submission regarding the bright line test having been rejected in this decision in Sony Ericsson is concerned, the court notes that the decision in Sony Ericsson expressly negatived the use of the bright line test. Once the bright line test is negatived, there is no basis on which it can be said in the present case that there is an international transaction as a result of the A&P expenses incurred by MSIL. And if there's no international transaction, there can be no TP adjustment, right? So although the revenue seems to contend that the BLT was used only to arrive at the quantum of TP adjustment, the order of the TPO in the present case proceeds on the basis that the international transaction can be inferred only because the A&P expenses incurred were significantly higher than what was being spent by comparable entities. The court does not agree with the submission of the learned counsel for the revenue that the BLT, the cause of the BLT, the existence of an international transaction on account of the incurring A&P expenses can be established. So no international transaction, no TP adjustment, and Maruti Suzuki won the case. The court then went on to say, as rightly pointed out by the SSC, while such quantitative adjustments involved in respect of A&P expenses may be contemplated in the taxing statutes of certain foreign countries like the US, Australia, New Zealand, in other words, English countries, no provision in Chapter 10 of the Act contemplates such adjustment, and therefore the court ultimately decided that the taxpayer won and there was no grounds for an adjustment. In a way, I'm a little sad about this case because I really like the bright line test. I think it makes sense. I'm glad the court also said, you know, there are countries which allows this. It's just that in India you need an international transaction first, and of course in Europe we used to have that criteria as well, but that was stopped by European law in the Langhorst case, where the EU court basically said, you know, if you don't ask for transfer pricing documentation and adjustments between two companies in the same country, you can't ask it for two companies in different countries, because then you are infringing on the freedom of establishment within the EU. And I mean that case had it had very logical consequences. I mean, make no mistake, you know, this was about interest deductions which could have been paid, which could have been deducted if they were paid to a German entity, but could not be deducted because they were paid to a Dutch entity, and that was clear discrimination. But when it comes to TP documentation requirements and following transfer pricing rules, Langhorst does not always make sense within the same country. But I think the bright line test may not apply in India, but it definitely should be alive and kicking in many other countries. Also for imputing transactions for which there may be no actual transaction documentation, because you're just following the OECD guidelines, which says that you've got to delineate the actual transaction, and there may sometimes not be an agreement for the actual delineated transaction. This is what I wanted to say about the bright line test in India and around the world. I think it's a useful transfer pricing instrument, as the court in India said, to be handled with care, because it can also lead to very arbitrary outcomes if you use it as an excuse, and definitely to be used with the right comparables and not the wrong ones, as the Indian inspector did. But I hope you enjoyed the case, and I look forward to joining you in my next video about another case. Bye for now.